friends, welcome to the Point. In this session, we are discussing about interstate relations. For Indian federal system, it is functioning successfully. It depends not only on the harmonious relations and close cooperation between center and the state, but it also depends on the interstate relations. And therefore, our constitution, it had made certain provisions with regard to the interstate committee. They are adjudication, that is a formal judgment of interstate water disputes, coordination through interstate councils, mutual recognitions of public acts, records and judicial proceedings, freedom of interstate trade, commerce and intercourse. In addition, there are also zonal councils have been established by the Parliament to promote interstate cooperation and coordination. Interstate water disputes. Article 262. Article 262 of the Constitution, it provides for adjudication of interstate water dispute, that is a formal judgment of interstate water dispute. So in this case, it makes two provisions. Parliament may by law it provide for adjudication of any dispute or a complaint with respect to the use, distribution and control of waters of any interstate river or river valley. Parliament it may also provide that neither the Supreme Court nor any other court is to exercise jurisdiction in respect of any such dispute or complaint. So Parliament says that either Supreme Court or any other court, it should not exercise in respect of water disputes between the interstates. Under this provision, the Parliament has enacted two laws, that is the River Boards Act 1956 and the Interstate Water Dispute Act 1956. The River Boards Act 1956, it provides for the establishment of river boards for the regulation and development of interstate river and river valleys. A river board, it is established by the central government on the request of the state government which is concerned to advise them. And the Interstate Water Disputes Act, it empowers the central government to set up an ad hoc tribunal for the adjudication of the dispute between two or more states in relation to the water of an interstate river or river valley. The decision of the tribunal is the final and it is binding on the parties to the dispute. And neither the Supreme Court nor any other court have their jurisdiction in respect of any water dispute, which may be referred such as tribunal under this act. Only in extrajudicial machinery in between the interstate water disputes, the Supreme Court will have its jurisdiction to decide any disputes between the states in connection with the water supplies, and if legal rights or interest or consent. And so far, the central government, it has set up 8 interstate water dispute tribunals. Interstate Councils. Article 268, it contemplates the establishment of an interstate council to effect coordination between states and between the center and the states. And therefore, the President, he can establish a council at any time if it appears to him that the public interest would be served by its establishment. Article 263, it specifies the duties that can be assigned to any interstate council in the following manner, like inquiring into and advising upon the disputes which may arise in between the states, investigating and discussing the subjects in which the states or the center and the states have a common interest, and making recommendations upon any such subject and particularly for the better coordination of policy and action on it. The Council, it functions to inquire and advise upon interstate disputes in complementary to the Supreme Court's jurisdiction under Article 131 to decide a legal controversy between the governments. The Council, it can deal with any controversy whether they are legal or non-legal, but it functions is advisory in nature. Establishment of Interstate Council. The Sarkaria Commission on Center-State Relations, it made a strong case for establishment of a permanent interstate council under Article 263 of the Constitution. Sarkaria Commission, it also recommended that in order to differentiate the Interstate Council from other bodies which is established under the same article, it must be called as Intergovernmental Council. And the Commission also recommended that this council, it should be charged with the duties that is laid down in clause B and C of Article 263. So according to the recommendation of Sarkaria Commission, the council, the Interstate Council, it consists of the following members like Prime Minister as a chairman and Chief Ministers of all the states, Chief Ministers of Union Territories, which has the legislative assemblies, and administrators of the Union Territories and not having legislative assemblies, governors of the state under President rule, and 6 central cabinet ministers, including the Home Minister, to be nominated by the Prime Minister. 5 ministers of the cabinet rank or ministers of the state nominated by the chairman of the council are permanent invitees to the council, and the council is said to be a recommendatory body on issues that is relating to interstate, center and state, and center and union territory relations. The aim of this Interstate Council is to promote coordination between them by examining, discussing, and deliberating on interstate issues. And this council, it may meet at least thrice in a year. Its meetings are held in a camera and all questions are decided by agreement. There is also a standing committee of the council, and this standing committee, it was set up in the year 1996 for continuous consultation and processing of matters for the consideration of the council, and it consists of Union Home Minister as a chairman and 5 Union Cabinet Ministers and 9 Chief Ministers. This council, it is assisted by Secretariat called the Interstate Council Secretariat. This Secretariat, it was set up in the year 1991 and it was headed by a Secretary to the Government of India. And from 2011, the Standing Committee, it also functions as a Secretariat of the Zonal Councils, Public Acts, Records and Judicial Proceedings. So under the Constitution, the jurisdiction of each state, it is confined to its own territory. Hence, it is possible that acts and records of one state may not be recognized in another state. To remove such difficulties, the Constitution contains full faith and credit clause which lays down certain principles like full faith and credit, it is to be given throughout the territory of India to public acts, records and judicial proceedings of the center and every state. The expression public acts means for both legislative and executive acts of the government, and the expression public records means the records that is made by a public servant in discharge of his official duties. The manner in which and the conditions under which such acts, records and proceedings are to be proved and their effect is determined would be as provided by the laws of Parliament. This means that the general rule, any general rule that is mentioned in this subject, it is to power the Parliament to lay down the mode of proof as well as effect of such acts, records and proceedings of one state in another state. Final judgments and orders of the civil courts in any part of India are capable of execution anywhere within India. And the rule, it applies only to civil judgments and not to any of the criminal judgments. So we can also say that the final judgments, it does not require the courts of a state to enforce the penal laws of another state. Interstate trade and commerce. Article 301 to 307 in part 13 of the Constitution, it deals with trade, commerce and intercourse within the territory of India. And Article 301, it declares that the trade, commerce and the intercourse throughout the territory of India, it shall be free. The object of this provision, it is to break down the border barriers between the states and to create one unit with a view to encourage the free flow of trade, commerce and intercourse in the country. The freedom under this provision, it is not confined to interstate trade, commerce and intercourse, but it also extends to intrastate trade, commerce and the intercourse. Article 301 will be violated whether restrictions are imposed at the frontier of any state at any prior or at the subsequent stage. The freedom that is guaranteed under Article 301 from all the restrictions except those which are provided for other provisions. They are: the Parliament can impose the restrictions on freedom of trade, commerce and intercourse between the states or within a state in public interest. But the Parliament, it cannot give preference to one state over the another, or it cannot discriminate between the states except in the case of scarcity of the goods in any part of India. The legislature of a state, it can impose reasonable restrictions on the freedom of trade, commerce and intercourse with the state or within that state in public interest. But a bill that is meant for this purpose, it can be introduced in legislature only with the previous sanction of the President. That means the legislature has to take a prior permission from the President. The legislature of a state, it can impose on goods imported from other states or the union territories any tax to which similar goods manufactured in that state are subject. This provision, it prohibits the imposition of discriminatory taxes by the state. The freedom under Article 301, it is a subject to nationalization laws. That means that is the laws providing for monopolies in favor of center or the states, and therefore the Parliament or a state legislature, it can make laws for carrying on by the respective government for the purpose of trade, business, industry, etc. The Parliament can also appoint an appropriate authority for carrying out the purposes of the provisions mentioned so far. Zonal councils. The zonal councils, these are statutory and not the constitutional bodies. Zonal councils are said to be statutory bodies, and these are established by an act of the Parliament, that is the States Reorganization Act 1956. The act divided the country into 5 zones: northern, central, eastern, western and southern zones, and provided a zonal council for each zones. While forming these zones, several factors have been taken into account, and that include natural division of the country, river system, and the means of communication, cultural and linguistic affinity, and the requirements of economic development, etc. Each zonal council, it consists of members. They are Home Minister of the central government, Chief Minister of all the states in the zone, and 2 other ministers from each state in the zone, and administrator of each union territory in the zone. These are the members of the zonal council. Advisors associated with the zonal council. That is, these advisors, they don't have a right to vote in the meetings, but they are meant only for advisory purpose. And that persons include a person who is nominated by the planning commission and the chief secretary of the government of each state in the zone and the development commissioner of each state in the zone. The Home Minister of the central government is the common chairman of these 5 zonal councils, and each chief minister acts as a vice chairman of the council by rotation, holding office for a period of 1 year. The objectives of the zonal councils are to achieve an emotional integration of the country, to help in arresting the growth of acute state consciousness, regionalism, linguism, and particularist trends, to help in removing the after effects of suppression in some cases, so that the process of reorganization, integration, and economic advancement, it may get synchronized. Zonal councils enable the center and the states to cooperate with each other in social and economic matters and to exchange ideas and experience in order to evolve uniform policies between them, to cooperate with each other in successful and speedy execution of major development of the projects, and finally to secure some kind of political equilibrium between different regions of the country. Apart from the 5 zonal councils which we have seen earlier, there is one more council called Northeastern Council, and this council, it was created by a separate act of parliament, that is the Northeastern Council Act 1971. And Northeastern Council Act's members include members from Assam, Manipur, Mizoram, Arunachal Pradesh, Nagaland, Meghalaya, Tripura, and Sikkim. Its functions are also similar to those of zonal councils, but with certain few additions. It has to formulate a unified and coordinated regional plan which covers matter on common importance. This council, it has to review from time to time the measures taken by the member states for maintenance of security and public order in that region. See you in the next session with some other interesting topic. Thank you.